Good afternoon. This is Corey Ingber, partner at Ingber&Weinberg, and this is now Thursday, March 5th, 2020. This is the inaugural broadcast beginning of our podcasting from our Woodland Hills offices of Ingber&Weinberg. It's called 3 Minutes with Ingber&Weinberg, and it can be viewed not only on our website, found at www.icomplaw.com, but also on our new YouTube channel, YouTube, that's one word, .com / Ingber&Weinberg, one word, IW3'S. I know you're busy and you're jammed and you've got time deadlines and endless tasks to do. That's why we're keeping this to be 3 minutes. It may be a little bit more, and please don't punish me. But 3 minutes should be sufficient to cover a selected topic that we will find of common interest in our ongoing efforts to educate our friends, our clients, and our followers. I encourage you to email me with your ideas and suggestions for future podcasts. My email address is corey@icomplaw.com. Wow. You know, this is my 7th or 8th take, and I think I'm going to run through this no matter how badly it is. I never knew how difficult it is to speak for even 3 minutes from a semi-script, although I'm not going to read this. I'm going to refer to some rules. Anyway, today's topic is a simple one, but a troubling one. Is a lien claimant now a party to a workers' compensation claim by virtue of the new rules of practice and procedure? They came out in January, and there's lots of rules that are important. Some of the existing rules have been republished. Some of the existing rules have been modified and amended, and some of the rules have actually changed. They've actually added new rules. I'm not going to regale you with lots of code sections, but I want to call your attention to the biggest change, which is really in the definition of a party. 1030503, that's small o, small 3, now defines a party to include a lien claimant. This is a departure from the practice of the past, when lien claimants were not parties unless and until the case in chief resolved or the applicant dismissed or decided not to pursue his or her claim. So now they're parties. And there's another section that also requires parties to a workers' compensation claim to serve medical reports upon lien claimants upon request. There's a lot of provisions there, and I'm not going to go through each one, but essentially, if the lien claimant is a physician, or they're a healthcare service provider, or they're a disability insurer, or they're a self-insured welfare benefit plan, they have the right to receive medical reports in the case upon request. However, the board rules make a very sharp distinction between a physician lien claimant and a non-physician lien claimant. The non-physician lien claimant is not entitled to receive medical reports unless and until the board makes an order to do so. And that order shall come only if the non-physician lien claimant makes a proper petition before the appeals board, setting forth good cause and why the information is material to the proof of their lien. So be careful and make sure that any request from a lien claimant is scrutinized to be sure that you're not going to indiscriminately send medical reports to a non-physician. Now, step 1, make sure that you know you have a lien claimant. And the way you know that is to look on EAMS. Either the lien has been filed or it hasn't been filed. If it hasn't been filed, then it isn't a lien, and therefore there's no lien claimant because there's no ancillary jurisdiction. And the lien claimant has to be the lien claim has to be properly filed with a proper filing fee, unless you're a disability carrier or welfare insurance plan, healthcare provider, then there's no filing fee. There also has to be a supporting declaration that the lien is accurate, that the services in fact were offered and delivered, and that the pricing is accurate, and so forth. Without those requisite documents, the lien is not perfected, and the imperfection means that you can't have a unperfected lien claim producing entitlement to have someone portrayed as a party. So the lien process has to be full, complete, and compliant. The next question would be, what happens when the lien claimant becomes aggressive and they send defense counsel or you a letter saying, we're a lien claimant, welcome to our party, or we'll welcome ourselves to your party, and we want the following documents. We want the claims file, we want the legal file, we want depositions, we want discovery, we want subpoenaed medical records, we want wage statements, we want witness statements, sub rosa evidence, you name it. My advice is this: the lien claimants are parties in name only, and to fortify that judgment on my part, I turn your attention to something that was supporting these new rules, and that is the final statement of reasons, which you can find at the GWC website under regulatory actions. And what the commissioners, what the administrative director wrote, among other things, is the following: the changes are not intended to substantially increase the rights of lien claimants vis-a-vis applicants and defendants, because lien claimants already enjoy most of the rights of a party under current law. So there were fears that calling them a party would make them, eligible to be at every deposition and to participate in every hearing and so forth. Here's my advice, and I hate giving out general legal advice, especially on a podcast, but this is my opinion, so it segues into advice. Be conservative and understand that you have a duty to protect the injured workers' indiscriminate or negligent disclosure of medical information, even though HIPAA is not specifically applicable to workers' compensation. So, number one, I would recommend sending nothing to a lien claimant other than medical reports requested by a physician, doctor, or a disability care or health service provider. If there are any other category, there are photocopy, interpreters, clinics, chiropractic clinic, although I guess they're physicians, but some that's not a physician, durable medical equipment, pharmacies, they should get nothing without a board order. And I would not provide them with any document in the absence of a board order. Do it under the auspices of a board order. Then you can appeal the order or you can follow the order. But at least you don't make a mistake as to whether or not you should or should not have disclosed this information. I wouldn't want a lien claimant at my depositions. I'm certainly not going to invite them, notice them, or provide them with any copies of transcripts. I don't think they're entitled to it without a board order. I would also argue that the board rules retained 10742B, which says that no DOR shall be filed by a lien claimant unless and until the case in chief has been resolved or the applicant has decided not to pursue his or her workers' compensation case in chief. Therefore, they remain secondary parties, in my opinion, and I don't believe that the board, or the administrative director, ever intended to make lien claimants full parties to be served with every document and everything else. Now, obviously, if you see an R case, or even if you stipulate a case, and you have an unresolved lien, you have a duty to notify the lien claimants and serve them with evidence. But that's only when the case in chief has been resolved. But we're talking about whether a lien claimant can be characterized as a real party in interest, or a real participating party in fact, before the case in chief is resolved, and I would say no. So I would argue that most of these board rules are less egregious than I would have otherwise thought at first glance, and my advice is to remain calm and treat the lien claimants with great respect, as you should everyone else, but I would respectfully say no. And if they want documents, they have to get a board order. So hopefully I have overrun my time. I don't have any lawyer jokes for you, but I'll bring up some next time, and I'm hopefully next time I'll have a smoother presentation. Again, I can't imagine being an actor and having to do this for a living. 3 minutes is like 3 hours. Anyway, and I didn't bill for it, so it's good. Anyway, I want to thank you all, and God bless and be well. Thank you.